This lecture too is, I think, very important in that it talks about law, the pursuit of law. It is Unit 3 and Lecture number 8. It talks about trends and struggles and the implications of what's going on, and I think it's quite important. The the pursuit of law is something that Muslims are very, very interested in, because early in their history they more or less concluded, in other words, they decided that the Sharia was a system of commands imposed on society from above, and so the goal of Islamic jurisprudence became to discover pure law. And it was rather an introspective view, and the result was definitely quite narrow and rigid. For example, a medieval Islamic court consisted of a qazi or qadi, a judge of the law, who had to decide a case based solely on the testimony of witnesses. Like, for instance, proof of adultery required 4 male witnesses, but there was no jury, no system of cross-examination, and no way to appeal the decision. The judge may have reason to question the integrity of the witnesses. Incidentally, 2 women were equal to 1 man, but they could not search out the facts. Understandably, jurists often shunned the office of judge because the system was designed to pass over several offenders rather than condemn an innocent person. Now, the sources of law are 4. This is probably something that you already know about, but the 4 sources of law had to do with in other words, we're talking about Sunni law, we're talking about the Quran, which would be understandable, and we're talking about the Sunnah as it's found in the Hadith. You see, this is the fine distinction here, where you're actually looking at what was done, not just the written record, but what was done by the Prophet. Third, it's a matter of qiyas, which is juristic reasoning by analogy. What is meant by that is that if you can look back in the past and find an analogous situation, and whether this and this and this happened, so yes, that corresponds to the deal we're facing right now, so you draw from that. And then fourth, ijma, which is consensus or agreement of the community for the final outworking of the law or bodies of law. The Sunni school of law, which was, in other words, they have divided up into 4 founders, that's named after their founders. The Hanafi were followers of Imam Abu Hanifa, who died in 767. See how far back it goes. Maliki, who followers of Imam Malik, who died in 795. Shafi, rulers of Imam Muhammad Idris Ash-Shafi, died in 819. And Hanbali, followers of Imam Abu Hanbal, who died in 835. Now, that I just given to you, but let's think of where these particular schools of law resided. In other words, what's the location? Where were they? Well, they gained popularity in different parts of the Muslim world. And the Hanafi school was what we had in Pakistan, but also covered in India and most of the Middle Eastern countries. The Maliki school was popular in Northwest and in Central Africa, and the Hanbali school in Saudi Arabia, Shafi school in East Africa, Southeast Asia, and the Southern Arabian Peninsula. You see how vast the Muslim world is. It's quite amazing, really, when you think of the scope of it, and it is to their credit that they agreed to disagree. because there are some distinctions between in these four schools of law. So Muslims have not always been, in other words, it's not that they have to force one school of law on everybody. And then, in a certain time of their period, near the end of the 10th century, this is what happened. They decided to close the gates. And I think this is very, very important to recognize this. They closed the gates near the end of the 10th century. And I think it's really a major problem for Sunni Muslims. Leading ulama, in other words, the scholars, concluded that every important question about Islamic jurisprudence had now been answered. And so they closed the gates of ijtihad. And from then on, the task of jurists was to refer back to the commentaries of ancient scholars. You see how stale and musty and stagnant this could become. From then on, the task of jurists was to refer back to the commentaries of ancient scholars. As a study of the Caliphate reveals, taqlid was born. What's taqlid? Taqlid is imitation. But this viewpoint was not present at the beginning. The annals of Islamic history reveal that this inflexibility had gradually evolved in Orthodox Islam. See what's happened. So what's the final result here? The final result is intellectual stagnation, apathy, and division. Now, ultimately, this met with some strong opposition, resistance. It came from people like Muhammad Abdu of Egypt, who felt that if Islam was to speak to the burning issues of the day, the gates must remain open, and must rather be reopened. And in India, the modernist Muhammad Iqbal, who, as I've said before, was the father of Pakistan, he came up with the idea. He wasn't the founder, but he was the father of it. He offered the most scholarly resistance to such unthinking rigidity. And because they did not want to be bound by the conservative ulama, fundamentalists supported it in theory. They supported the ijtihad. But since they withheld interpretive privileges from modernists, in practice, they're not much different. So you see, do you understand that even though the fundamentalists said, yes, we must have ijtihad, yet they said that the people who decide, they've got to be like us. We can't allow anybody, any modernists, to help make a decision as to what's right and what's wrong. So, as I've mentioned, this was certainly intellectual stagnation, apathy, and division. And one wonders why they did it. In other words, they seem to want to come up with a foolproof system. Now, let's just take an example here of some sticky question. In other words, questions that are not easily solved unless you have an airtight system. For instance, let's look at marriage laws. All schools, that's 4 schools, say that a Muslim can have 4 wives, but not all agree on how to handle marital conflict. A husband might angrily say to his wife, I divorce you, I divorce you, I divorce you, only to later regret it. But the law said he could take her back. Rather, he could not take her back until she was married to another, and the marriage had to be consummated. So, Hanafis and Shafis used eunuchs and young boys to fulfill all righteousness. Hanafi said an ill-treated wife could not file for divorce. But in 1953, this law was liberalized in Syria. Other Muslim countries adopted similar approach in search of balanced family laws. I know that Pakistan did, which is to their credit. But you know, back to the sticky question of marriage, it wasn't just that a husband might in anger say, I divorce you, I divorce you, I divorce you. But I heard just recently a case where some man, just in jest, either he sent his wife an email or said it on Facebook, I don't know, I divorce you, I divorce you, I divorce you. and that got around and was sent to judges and so on, and so they're going to hold him to it. But he was just joking. That's what he said. And unfortunately, you can't joke like that because of the rigidity of the law.